Hello, everyone, and welcome to the Adams & Reese Financial Services webinar series. I'm Angela Grewal, and I practice with the Commercial Restructuring and Bankruptcy team in our Jacksonville office. I would like to welcome you to today's program, where we will discuss preferences in fraudulent conveyances in bankruptcy and strategies for avoiding liability. With me today are my colleagues, Hank Shelton from our Memphis office and Charlie Cook from our Nashville office. Hank and Charlie also focus on commercial restructuring and bankruptcy in their practice and frequently counsel clients in the financial services sector. Through our work, we have defended clients against millions of dollars in preference and fraudulent conveyance claims. Just a little housekeeping before we get started. We would love to hear from you today. If you have any questions during the presentation, please type them into the question box in your control panel. Only our presenters will see the questions submitted, and we will have time to address them at the end. Also, we are recording the program today, and we'll be sending you an email with the link so you can share the content with your colleagues. We will also send a copy of the slides to you. The program has been pre-approved for 1 hour of CLE credit in 7 states, and we will be submitting your attendance with state bars as indicated on your registration form. It has also been approved for 1.25 Certified Lender Business Banker CE credits by the American Bankers Association. Now I will turn it over to Hank.
Thanks, Angela. Let me start by talking about the bankruptcy court system, because it's only in the bankruptcy court system that these particular issues of preferences and fraudulent conveyances come up. Bankruptcy courts were created by Congress, and Congress was assigned the responsibility for creating the bankruptcy system by the Constitution. The bankruptcy courts administer the bankruptcy code. The bankruptcy code sets out a lot of things in accordance with congressional policy. The congressional policy for bankruptcy has several aspects, some of which really impact this question of preferences. The first idea of bankruptcy policy is that bankruptcy courts will supervise either the liquidation or the reorganization of a debtor's estate. The point being to administer that estate, which consists of all the property the debtor had before the debtor went into bankruptcy, was put into bankruptcy, file Chapter 11, file Chapter 12, file Chapter 13, file Chapter 15, or file Chapter 7 or 9. The idea is the same: create an estate consisting of all of the debtor's property, and all the debtor's property includes the debtor's claims, so that it can be fairly administered for the benefit of the creditors, not of the debtor. The first thing that happens when a petition is filed is everybody has to stop trying to collect money from the debtor. That's referred to as the automatic stay. Once that happens, the trustee in a Chapter 7 case, or the debtor in possession, usually in a Chapter 11 case, administers the estate under the rules that the Congress has set for that administration. I want to focus on one aspect, and this seminar will focus on one aspect of those rules and that administration, and that is what we call generally avoidance actions. An avoidance action gives the trustee, and I'm just going to call him the trustee, although sometimes it's the debtor in possession or other persons. The trustee has the right to avoid actions that the debtor took or actions that people took against the debtor, hence the term avoidance actions. But the purpose of those avoidance actions is to create equality, so all creditors of each class are treated the same. There are all kinds of different classes in bankruptcy. There are secured creditors and government claims and tax claims and priority employee claims. But for preference purposes, we're really just focused on what we call general unsecured claims. For most businesses, that would be trade creditors. It would not be usually banks or secured lenders. And the Congress wants all bankruptcy creditors to be treated the same. One particular aspect, and let's look at the next slide and talk about this. One particular aspect of making things equal is what we call a preference action. Let me break that one down really simply by way of an example I use with my own clients. And that is this: assume I'm the debtor. Assume that I owe $10,000. Assume that I have $1,000 and that I owe 10 people $1,000 each. Now, what I could do in my home state of Tennessee is pick a particular favorite of mine, say Angela, and pay her debt of $1,000 in full, and then go into a state court proceeding, a receivership of some kind. In that case, Angela keeps her $1,000, and my other 9 creditors, including Charlie, get nothing. That does not work in the bankruptcy court. In the bankruptcy court, my payment to Angela, if it was made within 90 days, is what is called a preference. And my trustee can sue Angela for the $1,000 that I paid her, take his commission out of it, and distribute the remaining money, let's call it $900, $90 apiece to each creditor. That way, all unsecured creditors have been treated fairly. That very simply is what a preference is. It is a payment where I preferred one creditor to others. Now, obviously, receiving a preference can be a problem, right? Because you're going to get sued and you're going to have to give it back. But an important thing to remember about preferences is they are not illegal, immoral, or unethical. A preference is just a payment made when the policy of Congress is that payment should have been shared among everybody. So as we like to say, the only thing worse than getting a preference is not getting a preference. So not a bad thing to get one, but if you get a preference and you know it's a preferential payment, then automatically you might have an issue with the trustee if the debtor who paid you that money goes into bankruptcy. It is in effect a cost of doing business. With some large clients of mine, it's a built-in cost of doing business. And Charlie will address how they should deal with that later on in this webinar. But the important point is sometimes you're going to make a preferential payment. Now, there are limits on how that preference avoidance action works. For non-insiders, the preference has got to be made within 90 days. So going back to my basic example, if I pay Angela her $1,000 and then wait, instead of 3 months, 4 or 5 or 6 months to file bankruptcy, she has a defense. She did not receive that $1,000 within what we call the 90-day preference period. There is an exception to that rule, and that is if Angela is my sister-in-law. In that case, she's considered an insider under the code, and the preference period goes to a year, not to 90 days. So within that year, if I file bankruptcy, she is liable to being sued by my trustee to get that $1,000 back. The other rule that is maybe obvious from the example, but you need to remember this, is the only amount of preferential payments that you owe are the preferential payments that total more than you would get in a regular bankruptcy. So in our case that we were just talking about, what you'd get would be $100. If you got 1,000, you got $900 too much. If you got $150, you got $50 too much, which triggers yet another example because the code sets minimums on how much a trustee has got to have in preference claims before he can pursue a creditor, such as the bank. So reviewing this slide, the preference only comes if it paid a debt that accrued before filing bankruptcy and was paid before filing bankruptcy. It had to be within 90 days or within a year, and it had to be in an amount that got you paid more than you would have been paid in Chapter 7. Let me just mention another example about that Chapter 7 idea. Let's assume that in the Chapter 7, I actually had $9,000 or $5,000, good example, and I paid Angela $1,000. In that case, the preference would not be the $1,000 she got paid, but only the $500 that she got paid, which was $500 more than what she would have gotten in a Chapter 7. So let's look at the next slide. The preference action is a lawsuit, and it's brought under the Bankruptcy Code. And if it's just a preference, then that makes it a little bit easier to deal with. However, let's go back. There's another related kind of avoidance action that I think is considerably more dangerous than a preference action, and that's referred to as a fraudulent conveyance. Fraudulent conveyances come in two forms. There are actual fraudulent conveyances and constructive fraudulent conveyances. Let me put it simply, as I tried to do with the preference example. A fraudulent conveyance is a tool that a debtor uses to get his assets out from under his creditors. Sort of the classic example is putting the house in the wife's name, or putting a savings account in your husband's name. That is an act of actually taking an asset that would be subject to the creditors, back to my original example, taking that $10,000 and putting it in my wife's name or in my son's name. What I have done is taken my assets out of the reach of the claims of creditors with the intent to keep it, right? To avoid having my creditors get my $10,000 and at least making sure that it all goes to my family. That is fraudulent conveyance made with intent to hinder my creditors. The second piece of that is what we call the constructive fraudulent transfer, and that one's dangerous for a slightly different reason. In that case, the person who receives the fraudulent conveyance, let's say my wife receives it, hasn't gotten a preference. She has gotten money that didn't belong to me to give to her. She has gotten somebody else's money. So that kind of a fraudulent conveyance is very, very dangerous. Now, Charlie might go into this more, but as he points out, you will all remember the Sears case a few years ago. Sears and Kmart were related, but not the same. Sometimes Sears paid debts owed by Kmart. So somebody else using Sears money paid a Kmart debt. So the people who got Sears money arguably got a constructive fraudulent conveyance. The danger there is that preference period goes from 90 days all the way to 2 years for a fraudulent conveyance. Now, they're all dangerous. Clearly a preference is dangerous because you got money you had to give back. I've had clients who've had to give preferences back in the hundreds of thousands of dollars if they're trade creditors. That's painful. And that's the kind of planning that you want to implement to avoid, right? I've also had clients deal with fraudulent conveyances and fraudulent transfers. I will tell you that participating in an actual fraudulent transfer is dangerous on a number of levels, not the least of which is it is what we call an unintentional fraud. and you want to stay as far away from that as you possibly can. The constructive fraudulent transfer is dangerous for slightly different reasons and might, I underline might because it's not certain, also subject your business to a fraud claim. And I will tell you, as a lawyer who's been around more years than I care to admit, you do not want to deal with a fraud claim, even a bogus one. And you especially don't want to get tagged with fraud. So whether it's an actual fraudulent transfer or constructive fraudulent transfer is something you absolutely want to watch out for. So to sum up sort of my brief remarks, I would say this: prepare for preferences, prepare for preference exposure. Do not be afraid of getting a preference, because as I said, the only thing worse than getting it is not getting it. Because if you get it, the debtor might not ever file bankruptcy, right? And if you don't get it, if you turn it down because it's preferential, well, then you just lost it. So don't sweat getting a preference. Just make sure you plan for the eventuality that the person who paid it might be going into bankruptcy. Do pay attention to fraudulent transfers. So if you get a payment from somebody other than your debtor, think about it and maybe consult counsel. Thanks very much. And now I'm going to turn this over to Angela.
Thanks, Hank. So how do these preference and fraudulent transfer actions arise? An adversary action, which is an actual lawsuit that's brought against you by the debtor in possession or the trustee, and it's connected with the bankruptcy case. So it's typically filed in the same court, in the bankruptcy court, where the debtor filed for bankruptcy, which can occur in Delaware, in New York, could be completely out of the jurisdiction that you're typically in. Sometimes it is brought where you reside under 28 U.S.C. 1409. Any proceeding relating to a bankruptcy case against a non-insider to recover non-consumer debt of less than $25,000 must be commenced in the district where the defendant resides. And this amount, this limit at $25,000, was recently increased by Congress. But courts disagree about whether this provision applies to preference cases or not, because of a difference in language in the code between whether a case arises under the bankruptcy code or a case that relates to the bankruptcy code. But just be aware that you may be dragged into court into a jurisdiction that you're not expecting to be and you're not familiar with. Also important to pay attention is service. Rule 7004 bankruptcy procedure states that you can be served in the adversary action simply through first-class mail that's mailed to the attention of an officer, a managing or general agent, or to any other agent authorized by appointment or by law to receive service and process. So it's really important to pay attention, because you're not necessarily going to get served like you would think in a traditional lawsuit, and you don't want these complaints to get lost in the mail. Now we're going to switch show you an example complaint. Hank mentioned the Sears bankruptcy case, and this complaint stems from that. We have rejected any information that is specific to the defendant, but as I'm scrolling through here, I think you'll see that there's actually not a lot that we had to redact. A lot of times in these large bankruptcy cases, you're going to get these kind of form generic complaints where they plug and replace the defendant's name. They generically describe the parties. You'll see here, section 13, they talk about the defendant was a vendor or creditor that provided goods and or services to or for the plaintiff. Everything's pretty much a listing of the case background. They will say, here again, we'll see in 17 that it said the defendant and plaintiff entered into agreements for the purchase of goods and or services. And that's evidenced by one or more contracts, purchase orders, invoice communications, and other documents. So it's a form that was put together. They plugged in the amount of transfers that were made to the defendant that otherwise They simply list out the statutory elements that Hank just went over. Additionally, you'll see in this one, which we've seen a lot more, they put in there an avoidance of fraudulent conveyance claim as an alternative claim for relief, just arguing that, oh, if that wasn't a preference, then maybe it was a fraudulent transfer. We're seeing this a lot, even though maybe it's not as specific and doesn't have the specific elements that it should. Now, there is a new requirement, recent amendments to the Bankruptcy Code require the trustee to exercise due diligence prior to filing a complaint and to take into account a party's known or reasonably knowable affirmative defenses before filing suit. How this is going to play out is a little uncertain, and whether this will help curb some of these form generic complaints and save some expenses it's a little unclear, but hopefully that will help. So what are those defenses? There are 5 defenses that are laid out in the Bankruptcy Code itself: contemporary new value, ordinary course of business, purchase money security interest, subsequent new value, and a perfected security interest in inventory or a receivable. The purchase money security interest is when funds are used to purchase a specific item. The creditor has a security agreement describing that property. The funds are used only to purchase that item. The item is actually purchased by the debtor, and the creditor perfects their security interest within 30 days of the debtor receiving that item. The perfected security interest in an inventory or receivable is a floating lien. Only inventory, accounts receivable, and the proceeds thereof. These liens are not avoided unless the creditor improves its position. So the courts look at the position of the creditor in that floating lien as of the petition date versus 90 days prior to filing. And if the creditor has not improved their position, then this will be a defense to go front. Contemporaneous new value as basically what it sounds like, that you receive the funds in exchange for services or goods that were provided contemporaneously, so cash on delivery. In that case, it is a defense to a preference action. Ordinary course of business is one of the most common defenses. It can be very fact intensive. The argument is basically that payments were received in the regular course of the party's business transaction, so they should not be clawed back. This can be proved 2 different ways. There's a subjective test between you and the debtor. How did you and the debtor handle payments and business together in the past? There's also an objective standard. What was the standard in the industry? As I stated earlier, it's very fact intensive. You need to gather the facts and figure out, how did you handle the payments in the past? Did that change in the preference period? Ideally, no. If you continue to operate as you had in the past, then the payments that you received in the preference period were part of the ordinary course of business. So look at what's called the historical period, which is a period prior to that 90-day preference period. So look at 1, 2, 3 years back prior to the bankruptcy filing and your interactions with them. Look at when you got paid. When were the payments due per the invoice? Did they actually pay them? Did you allow them to pay late with no penalty enforcement? That's not necessarily fatal as long as you're consistent. If you have invoices that at 30-day payments, but they were regularly paid 60 days with no penalty, that's fine as long as you continue that course of conduct. Look at the weighted average of days between the date of the invoice and the payment historical period, and compare that to the weighted average of days between the date of the invoice and the payment in the preference period. If there are changes, that's a problem. So for example, if the debtor consistently paid you 30 days after the receipt of the invoice in the historical period, but they pay you 15 days after receipt of the invoice in the preference period, that's not ordinary course. And vice versa. If they regularly paid you 30 days in the historical period, but suddenly take 60 days to pay you in the preference period, that's not ordinary course. Courts have held that differences of 19, 23, and 29 days between the time to payment in the historical period and the preference period have been considered outside of the ordinary course of business. And unfortunately, it's not a bright line rule. You can't look up and say, okay, payment 5 days of difference are okay and 10 days are not, or 7 days are okay and 13 are not. You just have to look at the history. The closer, the better. You also want to look at how the payments took place. Were they paid with cash, check, money order? If they are consistently paying you via check in the historical period, but switch to cash in the preference period, that's not ordinary course. And again, vice versa. The change is the problem. On the objective test, you look at whether the payment terms and process are ordinary in the industry that you and the debtor are involved in. And you typically need expert testimony to establish this, so it can be expensive. But the creditor, the debtor, the court, you can adjust for the strictness of proof and whether testimony from non-experts as to what the standard in the industry is may be used. Subsequent new value. This is when you receive payment from the debtor and then you provide something of value. So a new shipment of goods, new services, etc. This new value can help to negate that prior preference payment. This encourages parties to do business with distressed entities and continue to do business with debtors. But can you include new value that has been paid as part of your defense? So for example, in the preference period, the debtor pays you for a past invoice and you provide a new shipment of widgets. And then they pay you for another invoice and you provide another shipment of widgets, and this continues. Can you use all of those widgets that were provided in the preference period to count for that new value, even though some of them might be paid? There's a split in the circuits. The majority, the 4th, the 5th, the 8th, the 9th, and the 11th have concluded, yes, you can include all of them. The 7th Circuit, however, has concluded no, stated that only unpaid new value counts in this defense. Finally, as Hank kind of mentioned earlier, there is a sort of remedy if you do have to repay preference recoveries that you received. Under 11 USC 502H, you get a general unsecured claim for any preference recoveries that you had to repay. However, you're in the general unsecured pool, so typically recovery of this is minimal, so you're not going to get the amounts that you received back. Additionally, if you do end up settling with the debtor generally requires you to waive this claim. All right, now we're going to turn it over to Charlie to discuss some strategies for avoiding liability.
Thank you, Angela. So I get asked, particularly in times like these when bankruptcy filings seem to be on the increase, by clients, particularly trade creditors, businesses that are typically doing business, selling either goods or services. For example, I've got a customer. I think this customer, I've seen in the news, this customer may file bankruptcy, or this customer has filed bankruptcy, and maybe this client has had some experience in the past with preference exposure, and so the question is, what can I do? What can my company do to avoid getting sued later for a preference? In some other cases, I get consulted when a client has already been sued and is outraged at the fact that they're owed considerable amount of money and now they're getting sued to give money back. And the question is often, well, how can I prevent this from happening in the future? There's some primary things to keep in mind here. There is really no one-size-fits-all approach to trying to mitigate or preventing preference exposure. There's obviously, like a lot of things, there's less options the longer company waits to deal with the potential for preference exposure for payments it's getting. Some other things to keep in mind here is that the side of the business that is selling to the customer debtor will likely want to keep doing business with that customer, even if it's late paying, particularly where that customer may have other options for buying services or goods and represents a large account. And so imposing conditions or terms on that customer where it might mean losing business is going to probably meet with some resistance from the sales side of a business. Similarly, if the debtor customer is a large customer, that debtor customer will likely be resistant to agreeing to any additional terms. So generally, and also to reiterate a point that Hank made earlier, generally speaking, it is always better to get paid than not getting paid. So if a customer is someone that you perceive as, on the maybe filing bankruptcy or in financial distress, and you're concerned about whether you should take a payment because you might get sued later for a preference, it's generally advisable to take that payment and worry about the preference suit later. It's not a foregone conclusion that the debtor sues to collect all the preferences. In a large case, it's likely, but again, it's not a foregone conclusion. And there's defenses. And in many cases, if you have at least some colorable defenses, you can probably negotiate, even if those defenses aren't necessarily ultimately, absolute winners. If they're enough to get you make a colorable argument, you may at least be able to settle down on your preference claims and not have to pay back 100% of the preference payments that are alleged. To some degree, I'd say that clawback, avoidance, and mitigation is a lot like diet advice. There's not really a silver bullet, but a disciplined approach is often the best strategy. All of the strategies that I'm going to discuss here, to some degree, are driven by considering the elements of the preference claim itself and the defenses. As you heard Hank talk about, whether the payment is, from the debtor, maintaining ordinary course, whether you're improving your position by getting the payment versus how you might do or in a hypothetical Chapter 7. Some of the strategies will also consider alternative sources of payment. So starting with sort of the more, I guess, less drastic, but sort of thoughtful strategies, communication is first on our slide. And that also goes to just basically internal communication and external, and maintaining records. For starters, monitoring and keeping track of trade debtors with potential for bankruptcy for filing. It may just be, just a starting point, sort of, it's not necessarily mitigating or preventing, but internally accounting for customers that your business suspects are in sort of a solvency risk area, going ahead and maybe accounting for 90 days worth of preference exposure to those customers, so that if a preference lawsuit is brought, that claim does not come as a surprise and is already at least accounted for. Another thing, to go to Hank's point about fraudulent conveyance exposure, some of these large conglomerate companies are set up where they've got different affiliated subsidiaries that may be taking in payments and making payments on behalf of other entities. And your business may be getting a payment from an affiliate of the entity that you're actually doing business with. You may want to confirm with that entity that that's the way that they're doing business, and that entity that's making your payment is that's authorized, and that's the way that they're doing business with their other entities like your business that's selling or goods or services. A lot of this is going to vary by business as far as whether your business wants to do this or can't, or how you account for it. It could depend on the amount of customers that your business has, the amount of transactions that are at issue, your business's internal accounting system, experience with tracking risky accounts, and whether your business really wants to or can devote internal resources to monitoring at-risk accounts. The other thing, it's an obvious sort of to look at is also gather up whatever contracts. If your business sees a customer that looks like they may be at risk of filing bankruptcy, you may have a specific contract with that customer, not just a series of invoices and payments. You may actually have a contract, a sales contract or service contract, and from time to time those start out maybe that form your business generated, or it's a form that your customer generated. At some point in time, one of the other entities has made adjustments to it. They may be adjusted by email or by some sort of amendment. But you should make sure what that agreement looks like in terms of what you can and can't do as far as imposing additional terms on that customer. If that contract's got another year on it or 2 years on it, and it provides for how payments are made and when they'll be made, then there may not be what you can do to adjust that. You may also want to look to see whether that there's defaults that you could declare. You may want to see whether it's got a cure period for late payments and those type of things. You also want to make sure, again, because these agreements sometimes get amended, that you've got the latest version of it and are aware of exactly what the terms are. You also want to be, again, as I said, with the 90-day preface exposure, you want to be monitoring the 90-day look-back period. And with that in mind, watch your receivables, get a sense, as Angela said, of how payments are being made, when they're being made, in comparison to when invoices go out, when payments are actually made, and whether that customer is sticking to the terms of your contract, and whether they're sticking to terms, just your general history. Again, sometimes a customer may not be paying according to whatever your contract says. If your contract or invoice is payable on 30 days and they're paying on 60, that's not great, but if that's the way they've been doing business over a year or more, or 2 more, then that may still be a viable defense to ordinary course. Also remember, and again, this gets into sort of conflicting situations. Payments that are coerced or treated differently are going to fall outside of ordinary course. So if you see a trade debtor trending late, you might want to think about how you communicate with that trade debtor. You may, because if there's any sign of coercion, that could be deemed to change those payments from outside the ordinary course. But also remember that you want to collect that debt, and that debtor may not actually file bankruptcy. So, that's not to say you shouldn't be trying to collect that debt and making for a forceful case to collect that debt. Just remember, there's a risk to that the more you put pressure, the more likely the trustee that brings that suit is going to argue that that's outside the ordinary course. Things the debtor's lawyer is going to ask for discovery, for example, to look at ordinary course is going to be whether you, as a business, reduce that customer's credit limit, whether you shorten payment terms, whether you change the mode of payment, for example, check to wire transfer, whether you withheld shipments or threatened to withhold shipments in order to get payments. What sort of collection effort, were you making? You might want to consider, for example, with a trade debtor that's, you think may file bankruptcy, avoiding any written evidence of a coercion, so that at least when you're communicating with them, it's oral. And what sort of internal communication you're having about those collection efforts. Again, to meet the sort of address the subjective standard of ordinary court, and try to keep that customer within its general payment history that you've established over time. As to the objective standard ordinary course, if you have any familiarity with what the range of payment history is in your trade or industry, then staying within those industry standards is also will provide you with some sort of a defense. There are resources that track this information that can be obtained from a price. There's industry consultants that keep this information. But again, it can cost money to obtain that information. One thing is to do not increase the customer's credit limit if you're concerned about the risk they may file bankruptcy. I think this advice is fairly self-explanatory. Another thing a business might consider if they're dealing with a risky customer is to raise prices to that customer, is to account for the heightened level of risk. Prices may have already been negotiated and agreed to, so this may not be feasible. And this may not be feasible if there's a competitive environment and the customer is going to refuse, or the business side of your business is not going to agree to this. Another very standard strategy when you have a risky customer is to put that customer on cash advance or cash on delivery. This is basically making those would then become contemporaneous exchanges when you're getting paid for that service or product you're selling. One commentator I read suggested, and I've never seen this one done, but shortening payment terms with the customer. Although that may affect the ordinary course defense, it actually improves the new value defense, because then once you've been paid, anything you've sent after that could then qualify for the new value defense. Some other things which I refer to as credit enhancements, and I'll go through these quickly. Getting a guarantee from a third party. This goes to the sort of element that the payment has to be by the debtor. So if your customer has an owner or an affiliated company, getting a guarantee from that affiliated company or owner that would cover both the payment. If there's a late payment, perhaps you want to call the guarantee, you get that payment made by that third party. That's not a payment by the debtor. You've also got that guarantee in hand to allow you, if you had to pay back a preference payment, you could then pursue the guarantor for not only that preference payment you paid back, but for the entire amount that maybe that you haven't been paid by that debtor after it's filed bankruptcy. Another strategy that has been suggested is getting a letter of credit. That's an independent obligation by a bank, not a payment by the debtor, so it should be exempt from the automatic stay as well. The one caveat or I add to a letter of credit is letter of credits can be a little tricky, because some courts have found that under certain facts there can be a preference if the letter of credit is drawn prior to the filing of the bankruptcy and within the 90-day. If, for example, the debtor had pledged collateral for the letter of credit, which then becomes impaired by that letter of credit draw. Also, as a practical matter, a debtor that's already in financial distress may not be able to get a letter of credit. And another issue is that making sure, for example, if you have a letter of credit in place and then you're about to draw it because the trade debtor has missed a payment, and then you are about to draw, and then that trade debtor makes you a payment, and then you release the letter of credit, and then that payment the debtor then made to you could be declared a preference, and you've lost the benefit of the letter of credit. So the letter of credit should be set up so that you could draw against it if you had to pay back a preference. So my advice on the letter of credit strategy is definitely seek legal counsel when you're setting something like that up. And again, there's a cost to it, and the customer is probably going to be reluctant to doing it. Another strategy is to get a deposit from the customer, or have the customer pledge a CD, it's pledged in your name, your business's name, that would be a payment that's not a payment by the debtor, or it allows you are not receiving more than you would be entitled under a liquidation under 547B5. Another strategy is credit insurance. I'm not seeing this used. I suspect it would be fairly expensive, particularly if you're going to get credit insurance for trade debtor that's already in financial distress. Another strategy is to establish a purchase money security interest. As Angela pointed out, that's a defense. This would require a security agreement, a UCC filing. It would require description of the goods, consent from any pre-existing lender. So again, like the letter of credit, this strategy is a little more complicated, costly, and would require some input from your legal counsel likely in order to make that work. Another strategy is to have a restructuring agreement in place. If you are late on payments, potentially establish that those regular payments under that restructuring agreement are ordinary course. If that restructuring agreement is put in place within the 90-day period or close to the bankruptcy filing, you're probably going to have a challenge to any of those ever being ordinary course. The last item I would point out is to consider is, credit card payments from the customer. That would be a payment from a third party. Generally, however, I think most businesses recognize that when a customer starts to pay by credit card, that's a sign of that customer is probably in financial trouble as it is. So those are some of my general recommendations and thoughts on strategies for avoiding preference risk. Again, there is no one size fits all strategy. There is no strategy that's necessarily absolutely the best. It really depends on the customer and your business and the relationship you've had. And with that, I will hand back to Hank.
At this time, we're going to address as many questions as we can that were posted through the Q&A. And the first one was, do you know how often preference claims are litigated? It seems to me that they are usually settled and often for far less than the trustee claims is due, as long as you have the documentation to show ordinary course defense. That's true. That's exactly right. The thing about bankruptcy courts is they are all about deals, always. And even if a trustee has got an absolute laydown, you are in good shape to go ahead and try to cut a deal. Let me just go with two examples. Years ago, I had a client very concerned about exposure, very large client, got sued for a very large preference. They didn't try to negotiate it, they just paid it. On the other hand, I've got an equally large client who just last year was sued for an $8,000 preference. And they told me try to settle it. So absolute, again, lay down liability, no question about it. And went back to the trustee and settled it for 40 cents on the dollar. So yeah, trustees always settle. There are always opportunities to negotiate. And preference litigation is in that respect just like any other kind of litigation. So always try to settle. Next question, Angela.
You're on mute.
This question is, what is the best defense as far as getting a quick settlement? Charlie, what are your thoughts on this based on your experience?
New value is a typically, am I on or am I still on mute?
You're on.
You're on.
Okay. New value is typically an objective evaluation where payments are netted against subsequent shipments or goods or rent or services. And so typically, attorneys will evaluate new value by generating, in a case where there's multiple payments and multiple shipments of goods or service invoices, typically generate a spreadsheet that tracks the payments that are at issue in the preference case, like the payment that was made 89 days from the bankruptcy filing, and the payment that was made 70 days, and then the payment that was made in most cases, it's 30. So you're talking about maybe 2 or 3 payments at issue, and then netting those payments, the date that payment is made, against when like more goods were shipped to that debtor or services provided to that debtor, like utility services and rent can be and occupancy can be netted against each other. But that's typically an objective standard of what is the value of the service or goods provided after that payment. And so if that's netted out, that's generally given, pretty much once that's shown to a trustee, you're going to get a credit, particularly in a state that, in a jurisdiction that provides for paid new value defense. The objective standard gets, or the ordinary course standard gets a little more subjective. But again, I've seen cases where if the spreadsheet shows payments made by clockwork at this, within a day of say it's net 30, and those payments are being made net 30 or net 31, net 29, generally the trustees will, or whoever's representing the debtor will generally relent on those. But if all you've got is ordinary course and there is sort of some variation in the payment history, some trustees or debtors representatives will hang on to those and want to negotiate, and it may take a while. And it depends on the case. Some cases tend to see settlement discussions earlier, and the lawsuits get filed earlier. In some cases, the lawsuits get filed towards the end, and it's a lot of cases then they don't necessarily, there's not a lot of interest on behalf of the debtor representative to settle those right away. But generally, a new value defense is going to be quicker and easier to explain to a trustee or debtor representative, and they're going to want to see invoices and other records that they may not have as well in connection with that. Another thing that has come up is some clients, you may not know to ask this, they may not know it's important, but if there's a security deposit, like a lot of utility companies will hold a security deposit, in which case that payment they received isn't necessarily improving how they're going to do in hypothetical chapter 7, because they've got that security deposit. So that's another thing to consider. Another question that was asked is there something a client can do to prepare to help the attorney negotiate a resolution with the trustee? Angela, can you tell us how you've handled that?
Yes, the number one thing that you've already talked about, I think we've mentioned a couple of times, is just preparing that spreadsheet, preparing that information showing the invoices, the date of the invoice, the date of the payments that were received, not only in the preference period, but in the historical period as well. That spreadsheet shows ordinary course of business. It shows subsequent new value. And that way, if you have that all together, it's something that trustees are going to ask for when they send out that initial demand letter, or the debtor's attorney is going to ask for. So if you have that prepared and ready to go, you can hopefully knock some of these out and settle them quickly.
I think we've got one more question, for Hank, and you may have already answered this, Hank, but how often do preference cases go to trial?
Well, yeah, like I said, preferences are litigation. They're civil litigation. They generally settle, and they don't often go to trial. Just depends on where you are. If you've got a particularly hungry Chapter 7 trustee with not much to do, you're going to have a trial. In some of the big cases, the ones that used to be filed only in Delaware and New York and are now being filed in Houston and other places, what we call mega cases, the trustee or the debtor in possession or the claims agent will actually establish a separate arbitration-like way to settle cases with mandatory mediation and mandatory disclosures. And that system actually works fairly well. And in those cases, you do tend to get a decent settlement. A decent settlement is, of course, defined as one that neither side likes. In those cases, for instance, trustees will normally, or debtors in possession or their agents will normally give 100% credit for new value, and will make a real effort at showing ordinary course of business. So both of those defenses in the large cases are handled with a real degree of sophistication. I think that's it. We'd like to thank all of you for allowing us to present this program to you today and for spending this hour of your day with us. Let me remind you that we recorded the session today, and we'll be sending you a link along with a copy of the slides and a certificate of service for continuing education preference, CLE credit, or for you bankers, that sort of credit. Our next webinar is scheduled for late October, and it's called My Borrower Filed Bankruptcy, Now What? Again, we're trying to lay out sort of the groundwork and the basics. We'll provide an overview of common issues when a customer or borrower first files for bankruptcy and best practices for financial institutions. Stay tuned for more details and registration information coming in the coming weeks. In closing, we'd like to mention that our firm has produced numerous COVID-19 related resources on our firm's website, which is adamsandreese.com, spelled out, adamsandreese.com. You can access content from the homepage, and it's organized by subject, including financial services, legal assistance guidance, cybersecurity, employment and business law, and government investigations. You can also find updates by following our firm's pages on LinkedIn, Twitter, Facebook, and YouTube. Thanks again, and have a good afternoon.